So we're so glad to have everyone joining us in on this call. Thank you for taking some time out of your evening. It's a pleasure for us to be with you, and I hope that our time together will be fruitful and we'll spend some time learning and listening together. Um, I'm going to do a few introductory slides and some information, and then we will give the time over to our presenter. We are glad to have your questions, and what we would ask that you do is you put those in the chat if you're having questions coming up during the presentation, and then we will take some time at the end to answer those questions in the chat. We will also open up some time for some questions as well live. If you don't feel comfortable or you don't want to put those in to the chat, that's fine as well. For those who may not know me, my name is Nicole Toledo, and I serve in the Georgia Cumberland Conference in Stewardship and Plain-Giving Trust Services. And I count it such a privilege to get to serve next to some amazing people. You'll see here that there are some other conferences that are represented as well. And so we welcome all of you from each of those territories. And I'll be introducing each of the different groups that may be represented with us. So here we have the Florida Conference team. Jen Frost has just joined their team, and so um, we're glad to see her come on board. Luis Reyes, Andrew Elliott, Maria Pino, and Adeli Galvis. And so if you live in that Florida area, these are the folks that will be there and glad to assist you and help you with those estate planning needs. As you can see here, this is Georgia Cumberland. This is my home territory, and I have Andrew and Matthew who work with us, as well as Candy, who takes care of our office administration, and we'll be glad to assist you in those areas. This is New Jersey Conference. We have Carlos and Rachel's here joining with us now. We have, oh, sorry about that. Let me go back. Kentucky, Tennessee. Silka and Karina are doing a great job there as well. And then we have Southern New England Conference as well, who will join us at times. I don't believe that they are on today, if I remember correctly, but they are there to assist as well. Each one of us in our departments have to go through a certification process. And so I will say off the bat, we are not attorneys. However, we are certified to do estate planning within our denominational work. And we have to go through certain processes to get that and keep our certification every year. Our departments also go through trust reviews, and that means that there is another entity coming in to see and check that we are doing things in a way that is legal, in a way that is organized. And so that keeps our departments running effectively. So we say membership has its privileges. As a member in one of our conferences, you can take advantage of some of these tools for these important legal documents. And so you will have a consultation with one of us as certified in Plain-Giving Trust Services. Will help many times with free basic documents, notary services to help get things signed. And then there's also an array of other things. And some of our upcoming webinars will be touching on some of those. We have one coming up on some tax benefits and things to keep in mind, especially as we do our end of year planning. And so I know we're going to talk a little bit more about some of these tools. There are also revolving funds available, revolving accounts for each different union. And if that's something that you're interested in, you can definitely contact your conference, the folks that we showed before, and they would be glad to help you with some of that. And then in some instances, you'll get also a free consultation with an estate attorney in doing some of this. So I would say take advantage of it. We are here to serve you, and it's a great opportunity. So a few housekeeping things. As I said, we're certified through the North American Division as Plain-Giving Trust Services officers. We're not attorneys, CPAs, and we're not licensed financial advisors. I would ask that you please keep your computer muted. And then, like I said, please ask those questions, put them into the chat while Andrew is presenting. We want to give him an opportunity to do his full presentation. And at the end, we will definitely have some time to go through those questions. And so, as I mentioned, Andrew is here with us today, Andrew McKenzie. And this is a little bit about Andrew, and I'll let you look at some of that for yourself. Personally, I have been working with Andrew for the last 4 years here in Georgia Cumberland, and it has been a real great pleasure. Andrew is very, very knowledgeable, but also very passionate about ministry and helping our church members. And so he has presented for us a few times at camp meeting, and this presentation is something that I see often come up. And so we're seeing more and more blended families, people who have spouses, or, they had one family with children, and then that spouse has passed, or they have divorced, and then they're looking at getting married again. And so, what are some of these legal implications, that can play into that? And that really is going to be our topic of discussion today. I'm really excited to hear. And so, I'm going to go ahead and turn it over now to Andrew and let him share our presentation. I believe I had asked someone to do an opening prayer for me, and I failed to do that. So, um, would someone go ahead and step in? I think I had asked someone. Yep. Go ahead, Silka. Thank you.
Heavenly Father, thank you so much that we can gather together and learn new things. You have given us brains that can absorb new things, and we can apply the wisdom to our lives. And so we ask that our minds are open, and that the Holy Spirit is with Andrew as he shares this information with us. And thank you for watching over us and loving us. In Christ's name I pray, amen.
Amen. All right, Andrew, I'm going to make you the host here,
Okay.
and the time is yours. Thank you so much for being
All
with
right.
us today.
Thank you. It's certainly exciting to be here. I do have a presentation I'll share in just a moment, but before I start that, I just wanted to say I am excited to be able to share the information. I have given this presentation one time before, and hopefully if you saw it before, it'll be even better this time. I will give a little bit of a legal caveat that I am licensed in 4 states, Georgia, Alabama, Florida, and Tennessee, and I also do some work in South Carolina because I have another lawyer that supervises me there. But this presentation is really designed to be general knowledge. I would hate somebody to rely on something they saw in here to their detriment. Obviously, if you're doing estate planning, I would suggest that you have it reviewed, if it's not by me as an attorney, by someone else for your specific circumstances. And we'll go ahead and see if I can get this thing working here. Share my screen there. All right, can somebody confirm they can see the screen? So we'll get started. This is, if you can see this picture, this is kind of what we dream of if we were getting married for maybe a second or third time in life, that it would look like this picture here, some kind of blissful experience for sure. So when we're looking at this topic of a blended family, it's often when people get married later in life. And so before we get into that, though, I'm going to get into a little bit of background of, the history of when people first get married can have an impact on when they might get married for their second or third time as well. And so one question I have for you, what do y'all think the average age is that people get married for the first time in America? And you can either put your answer in the chat, or I'm just going to kind of go through the presentation, but just think about what you think that might be and how that's changed over time. So if you look, can y'all see this chart? Just make sure. Okay. Yeah, I saw thumbs up. So if you look at this chart, you can see that the average age for a first marriage in America, the latest statistics from this chart was, it's gone up. So in the 1950s, the average age for a woman to get married was, about 20, age 20 or 21. And now that's more age 28. And for men, it's age 30. So the average age of the first marriage has gone significantly up, especially since the 60s and even the 80s. And so that can have an impact on, when you have kids often, if you're getting married later in life, you often start your family later in life. And so then if you're having a second or third marriage, you're often a lot older than you might have been if you had gotten married the first time when you were younger. So, this is the dream that we think of when we think about marriage. It's just an endless sunset, and we can sit there on the beach and just enjoy everything. And, this often is the way your first marriage is. But, unfortunately, we live in a sinful world, and death and divorce can really wreck our first marriage and can wreck a lot of things in life. And your dreams can be broken, as you can see in this slide. So, if you did have a marriage that ended the first time for divorce reasons, for death, how many of y'all think, what are the averages, the numbers of the people that get remarried after their first marriage ended? And this is some interesting information as well. And you can see in this chart, there's the difference between men and women. And so, and the numbers have changed a little bit over time. This just shows a chart from 2008 until 2023. But you can see that it looks like 18% of women are getting remarried, and about 34%, twice as much as the men, are getting remarried than the women. And those numbers used to be even higher, as you can see, looking kind of back in history. And so a lot of people are still getting remarried, and that's kind of what we're focused on today. So, what should you be thinking about before your second or third marriage? And there's really a lot you should be thinking about. One thing I get the question a lot is, should I get a prenuptial agreement? What does a prenuptial agreement do? And that's something that we'll go over a little bit here. So, a prenuptial agreement or prenup is a legally binding contract that's signed by a couple before marriage that outlines how their assets, debts, and spousal support will be handled in the event of a divorce or death. It essentially provides a framework for financial matters in case the marriage is to end. Now, here's some pros and cons. And, I get a lot of questions on these. People who are kind of reluctant to even think about that. And so you're looking at the pros, you're looking at it offers some clarity on financial expectations before you get into the marriage. That's a huge plus in the conversation. Even if you don't do a prenup, you should certainly be having those discussions before you get into a committed marriage.
Andrew, I'm so sorry to interrupt
Yeah,
you for a moment. I failed to remember to hit the record button
I
as
thought I
we were
heard it start.
starting.
I thought I
And
did hear it before.
okay, you did? Potentially you did, and
I
I
thought
missed it. Okay.
We are
I thought
recording,
I heard it
Nicole.
before.
In the top right-hand corner, there's a
Okay.
beeping red light.
Thank you.
Hmm.
Yeah, no worries. So looking at the chart, you can see that there are some pluses. It protects individual assets and inheritance. It outlines financial responsibilities. It also gives realistic expectations. This is especially critical in a situation where you might have one person who maybe doesn't have as many assets that they're bringing to the second marriage, and maybe they have a larger home, and maybe they're selling their home as you get married. They want to know what kind of protections would they have in case the person with more assets was to die first. And so having a prenup can help really create a plan for those kinds of things. It can help in estate planning, obviously, to have a prenup. And then on the con side, some people say it's kind of unromantic, to be sharing information about your finances before marriage. But honestly, it is something I think you should seriously consider if you do it, because if you don't do a prenup, it can create some unintended consequences that can be very devastating for your family and really not something you wanted. But that's something we'll talk about. Well, I get this question more than you think. And this is, can you have something called a post-nuptial agreement? Is that a possibility? I get this question, and the answer is it is legally possible, but let me share something with you. After you get married, there's something called post-marriage paralysis. This is a condition where the signature hand, whether it's right or left, on a person after they get married, when it comes time to sign the postnuptial agreement, they lose all strength in that hand and they're just not willing to sign the agreement. That's really the biggest problem with a postnuptial agreement. is if you're already married, the spouse who didn't want to sign that is going to be probably less reluctant to sign it then. But it is possible to have one done after marriage, but really the best time to do your planning is before you get married. So, what can and cannot a prenup do for you or your family? Well, on the left-hand side, you see the check marks here. Certainly, it can provide guidance on property, savings and inheritance, stocks and shares, income, business interest. Those are a lot of things it can protect against. Then also on the right-hand side, you can see some things it really can't address. Child custody. You cannot put in a prenup who you want the kids to go to if something happens during your marriage. Courts decide custody. Now, in your estate planning documents, which we'll get to in a minute, you can put some preferences in there which courts will generally honor regarding custody. Same thing with child support. Courts decide child support. You can't do a prenup and say that will cut out a child support obligation that's going to be typically issued by a court. You also cannot include in a prenuptial agreement enforceable provisions relating to personal matters, anything that's illegal, lifestyle choices. Like I get the question sometimes, can I put in my prenup that they will not be able to get remarried if something happens to our marriage? And no, you cannot legally do that. It's something somebody has a certain amount of freedom over. So, should you roll the dice and decide not to get a prenup agreement? And what I will say is, in some cases, you could. A lot of that will really depend on how good of a job have you done with regard to your estate planning. If you've got a good estate plan in place, you might not need a prenuptial agreement because your assets may already be titled in such a way, or you may already have a estate plan in place that would really make it where you didn't necessarily need one. So, what are some other things you should be thinking about before you get into your second or third marriage besides a prenup? And one of those you should definitely be thinking about is estate planning. It is critical to ensure that your assets are distributed the way you want after your death, especially if you're getting married later in life and maybe you have older adult children or just older children, even if they're not adults, and maybe your spouse that you're marrying doesn't have any kids, or maybe they have their own children that they are concerned about with their assets. That's what you really want to have an estate plan in place. Otherwise, you can have some unintended consequences there for sure. So one thing to think about is, I know a lot of people like Winnie the Pooh. I love Winnie the Pooh. And Winnie the Pooh says, people say nothing's impossible, but I do nothing every day. So one thing to look at is you can think about what will happen if you get married in a second marriage and you don't do any estate planning and you don't do a prenup. What will the outcome be? And it would surprise you how many calls I get where people are already married in their second marriage and they do not know what the outcome will be if one of them was to die as to who would get what assets. And that to me is very concerning because you should at least know what's going to happen if you don't have anything in place. And so that's part of what we're going to look at today. So what happens if you have a house and you get married and you don't have a will, you don't have a trust, and then you were to die and your new spouse, what will happen? So a lot of it will depend on how the deed on the house is deeded. If the house was just in your name, it could have a possibly different outcome than if it was a joint right of survivorship deed. That's a deed where both names are on the deed. And if one person dies, 100% of the house goes to the survivor between the names on the deed. So if that's the case, then the spouse will get 100%. A lot of the outcome without a prenuptial agreement will really depend on state law. And state law can have vastly different outcomes on what a surviving spouse gets, especially if it's a homestead. I know Florida is one of the states I do a lot of work in. And if you're in Florida, there's some very strong homestead rights that other states don't have. So in Florida, if you and your spouse acquired the house when you were married, then you can consider that your homestead, and you have certain homestead rights that are stronger in Florida than they are in other states. And so those are things that you really need to think about is kind of if you aren't going to do any kind of planning, what would the effect be? So at least you'll know what to expect if something was to happen to you or your spouse and see what the impact of that would be. So after your death, is there a way to allow for your new spouse to live in the house, but after that new spouse dies, then for the house to go to your kids or your family the way you intended. And I get this question a lot, and thankfully the answer to that is, guess what? Yes, you can definitely do that. It's called a life estate. That's when you can, allow for your property to go to your spouse for their life, and then once they pass away, then it can be passed on to your children or someone else, or even a charitable organization. So when you have a new spouse, estate planning is going to be a balancing act. And the two things you're balancing is you're wanting to kind of provide for your new spouse and uphold the obligation to take care of them, but you're also trying to make sure that you also leave an inheritance to your children and make sure that you're kind of balancing those in a way that's fair to both groups. So this is the life estate. It's a joint ownership that allows one person to remain in the house until their death. And then when it passes, it goes to whoever you named as remainder men is what they call them. But it's certainly men and women. This is how it works. You got a grantor. This is the life tenant. That's the person that's living in the house until they pass. And then it goes to whoever else you name here. So something else to think about if you're going to use the Winnie the Pooh approach and you're not going to do anything with respect to estate planning, it's what is going to probably happen when you pass is there's going to likely be a probate process, and that can be a difficult process. It can typically take 12 to 24 months. It can take way longer than that for sure. This slide shows an outline of the process of it. I'm not going to go through all this in detail, but you can see it is a multi-step process that is a lot of work and takes a lot of time, and honestly can be quite expensive as well, because typically most people are not capable of going through that process without a lawyer. So you're looking at paying an attorney. If anyone disputes anything that's in a will, then the cost can be astronomical. I recently had a case where the total value of the estate was about maybe $200,000. I was not involved in the case initially, but got involved later to try to resolve the case. And by the time we went to mediation and got the case resolved, half of the entire estate, over $100,000 in fees to the lawyer who was handling this. And that's pretty sad that in a $200,000 estate, half of it went to the lawyer's fees. And that was absolutely awful. Like I said, it wasn't my fees. This was before I even got involved in the case. And this can avoid that extreme expense and also the expense of just having property you can't do anything with. So can the probate process be avoided? And I will say the answer to that, in most cases, the answer is certainly yes, it can be avoided. Then you might be asking, well, how could you avoid the probate process? These are some of the ways, and we're going to talk about deeding is another way that's not on this slide that we're going to talk about as well. So you can create a trust, and we're going to talk about the different kinds of trust. You can be creative in naming beneficiaries on certain accounts. This is especially helpful for things like retirement accounts. You can do something called a payment on death designation for bank accounts. So creative titling is a way that you can avoid probate because you'll have the items passed directly to beneficiaries. You can also do some kind of joint ownership of property. As I mentioned before, there was the joint right of survivorship. It is possible you can put your kids, there's some pitfalls to it, but you can put your kids on the deed with you. Then whoever survives ultimately gets the property. That is a way to avoid probate, but there's some risk to that. Potential creditors could come if the kids end up having an issue where there's a judgment against them. It could jeopardize the house for everybody, and some other practical limitations to that as well. So other options, you could do some gift giving, but there are some concerns with that we'll get into as well. A lot of people say, why can't I just give my house to my kids now? And we'll get into why that might not be the best strategy. Sometimes it could work. So then people are like, well, probably should have something in place. This slide shows the differences between if you were to go down the road of just getting a will, and that's not a bad thing to have. A lot of people, or think that I don't really want to have anything in place. I'll just let my family deal with that. But a lot of times you can create a lot of unnecessary conflict by letting your family make decisions that you could have easily made before the time comes to, be able to make decisions to affect your family. So A trust is a way that avoids probate. As you can see here, probate's required with the will, but not with the trust. And there's also some privacy issues. When you go with a trust, in most cases, it's not something that's going to go through a public process where you have to file something in the newspaper. It's, more of a private process. It is easier to create a will versus a trust, but you get that time back because it can take you a year or two to go through the probate process. Whereas if you have a trust, usually there's no kind of probate or legal process involved whatsoever. And so it can definitely save you a lot of time on the other end. It does cost a little more to set up a trust, but honestly, relatively speaking, it's not that much a difference compared to the value that you get with having trust and being able to potentially avoid the probate process. So in the arena of trust, there are different kinds of trust. There's primarily a revocable trust and an irrevocable trust. The main difference between the two is revocable is just like it sounds. It gives you a lot of flexibility to make changes. You could even revoke the trust if you needed to down the road. Whereas the irrevocable trust is often called a kind of a one-way road. Once you set that kind of trust up, it is often impossible to undo without getting court intervention. And so you have to carefully consider whether that's a good option for you. Does not have as much flexibility, but there are still some things you can control in a non-revocable trust. And one of those is you control the ultimate distribution of the assets as long as you're not naming yourself as a beneficiary. So that's good. And you can also control who the trustee of that irrevocable trust is. And those are big pluses, even with an irrevocable trust that you do retain control over. Another difference between a revocable trust and an irrevocable trust has to do with control. The revocable trust, you're still in the driver's seat. You're able to make all the decisions relating to your own assets, the assets that are in the trust. Whereas in an irrevocable trust, you're having to name typically another trustee who, even while you're alive, will be really in control of your assets. Because if you have control over it, then creditors will say that they can get to those assets. But one of the big benefits of having a non-revocable kind of trust is it can provide asset protection against creditors and against even Medicaid liens, which we'll talk about in just a minute. So when you're looking at the irrevocable trust, you're thinking about long-term care needs possibly. Those can be very expensive. As you can see on this slide, nursing home care costs can easily exceed even the numbers on this slide. It can cost, typically $10,000 more or a month to have long-term care. And assisted living, that could be $50,000 or more. Even in-home care can be over $4,000 a month. And so the government has a program called Medicaid, which is a way to receive government benefits to provide for some of these expensive costs of going to a nursing home. But in most states, what they will do is if you qualify for Medicaid, they will put liens on your primary residence to help pay for the cost of that, but they don't execute the liens until after both you and your spouse have passed. Now, one thing to think about when you're looking at possibly going into a second marriage or third marriage, really even your first marriage, is even if you have a prenup in place, and even if you did all the financial and estate planning that you thought was necessary, you should be aware that that does no protection whatsoever against Medicaid liens. In fact, I had a situation not too long ago where there was a family who had a couple that had been separated for over 25 years, but they were still technically married, but they were still separated, did not talk to each other, did not speak to each other. Well, one of them needed to have some long-term care and ended up on Medicaid. Well, the other spouse, even though they hadn't talked for 25 years to each other, the other spouse had a home in a different state, and Medicaid liens for the spouse that that was on Medicaid ended up going on the spouse's house in the other state because even though they've been separated for 25 years, they never officially divorced. And the way the government considers it, if you are married, your assets are considered joint, even if you have a prenup in place, and the government can still put liens on your property. Now, there are some special considerations with regard to certain states like Florida that have that strong homestead exemption that I talked about before. That is a way that can protect your home in Florida, and I think Texas is also in that category against some of the Medicaid liens. So that is a protection there. But otherwise, in other states, you would want to consider a non-revocable trust to potentially protect against Medicaid liens. This would especially be relevant for people who maybe have a family history of certain conditions that could cause them to be on long-term care for a long time, like Parkinson's disease, something like that. That's something you would definitely want to consider long-term care. One thing important to consider is Medicaid has something called a 5-year look back period. That's a 5-year period of time that if any assets are transferred out of your name, either to a trust or to another person, within that 5 years before you need Medicaid, they will consider that a non-eligible transfer. And that's where you really need to do some advanced estate planning to potentially avoid Medicaid liens, especially if you're looking at marrying someone maybe that has health conditions that could be sooner rather than later. You would really want to start considering setting that trust up to meet that 5-year advance requirement. So let's ask some questions about what the effects are. If you're in a second marriage, people are asking me these kinds of questions. What will happen if I have a joint revocable trust with my new spouse? And if something happens to me, can my new spouse go and change the beneficiary designations on my joint revocable trust? And the answer to that is, guess what? Yes, they can. And a lot of people say, well, how can they do that? We set it up together. And that's because of the structure of a joint revocable trust gives typically both parties the ability to make changes after one of the other parties was to pass. And so if you're looking at a hybrid marriage, you're wanting to protect your kids from maybe a prior marriage or from earlier in life, you might want to consider some other tools. So one option that you could look at, this is a real powerful slide visual, is you could do separate revocable or non-revocable trust. And so this is a way that you could kind of protect from the other spouse being able to make any changes on distributions for assets that were yours that you brought to the marriage that you really want to leave to your family. Then you could just do a separate trust that's in your name only. And one option with these is you could still name your new spouse as the what's called successor trustee. That's if something happened to you, then they could still act in the role of successor trustee, but they would not have the power to change any of the distributions. They would actually have a fiduciary obligation to, follow the direction that you provide in your trust. And it is possible too that you can have a joint revocable trust. Sometimes people will do that with real estate. It will be a joint revocable trust on the real estate, and then they'll just say whoever the survivor is between us will own that asset outright, or maybe there could be a life estate to the other person, or there's some other options as well that you can do if you both have separate trusts. It's a way to avoid probate is you can do something called fractional ownership interest transfers. It's especially helpful in real estate. If you look aside, you see the different color apples. This is a way where you could, for example, if you had a house and you wanted to split the value of the house, but make sure that each of the respective families gets it and the other spouse can't change anything, then you can deed like 50% to one spouse's trust and 50% to the other spouse's trust. And then you can have different terms that will describe what happens to each of those respective percentages that are distributed to the other spouse. That's a very powerful way to ensure that assets are distributed the way that you want to, or better yet, to make sure they're not distributed in a way that you don't want them to be distributed. So I have done that in many cases, and that has been a powerful tool to kind of help, I hate to use this term, but split the baby, so to speak, to be able to share the assets. Now, there are some limitations to doing that. One of the limitations is when one spouse passes, then their trust still owns 50% of the house that the other spouse owns. And it's difficult to divvy up that outcome unless you're doing life estates or things like that when you only have half of the estate or half of a house that you're distributing, you can get into a lot of fractional ownerships, which can be difficult to manage as well. So be careful with that one, but it is a way to create an outcome that accomplishes the unique plans when you have a blended family. So here's another question I get all the time too, and that is, this is cheaper ways than getting two trust or possibly three trust, because that can be a little, a little higher cost than what some people are willing to pay. Even though, in my opinion, if you do need that kind of a plan, it's probably well worth the cost versus the consequence if you don't have something like that in place later. But there are some cheaper ways to avoid probate without a trust. And so not all of them really work too well with the blended family, and I'll talk about some of the limitations there. So one thing that you can consider is something called a transfer on death deed. Now, it's not available in every state. Florida has something called a ladybird deed, which is a transfer on death deed, and fairly recently Georgia started doing a transfer on death deed as well. Tennessee does not currently have anything like that in place. The only way to potentially avoid probate if you own real estate in Tennessee is to get some kind of trust in place, unless you do some creative deeding, which is the other option. But the way a transfer on death deed works is it's a revocable deed. So you can deed your property to your children, but you could reserve a life estate for your spouse in the property. So your spouse could live in the house their whole life. And then once they died, then the remainder would go to the children that you've named in the transfer on death deed. But it is a revocable deed, which means if you end up needing to sell the house or decide to change your plans, you can revoke the deed at any time. So that's certainly a plus with that. I get this question a lot. What if I just want to go ahead and deed the home to my kids now? Wouldn't that be a solution to not having to get a trust, not having to do with any, these transfer on death deeds? And it is an option, but I really would only recommend that you do that if the people that you're deeding the property to now live in the same home with you. Because if they don't, then they could potentially be on the hook for capital gains taxes, which can be up to 23.8%. And what capital gains taxes are, these are a penalty for selling property that is highly appreciated. In other words, if your parents bought it a long time ago, and while your parents were still alive, they deeded it to you, then you get the basis that they got in the property. So if you sell it later, it could be a huge difference between what the property was purchased for versus what it sells for, and that could be a much higher liability. So just deeding it before you die is not always the best option. You can also lose homestead exemptions when you do that. There's also a risk of liens going on the property. If you deed the house to your kids, then the kids technically own it. And then if they have some problem with creditors or go through a bad divorce, then you could potentially lose the house even while you're alive. So that's something I would really caution against, even though it is an economic way to avoid probate, but it can often lead to a worse result. So let's talk a little bit about something called a spendthrift trust. Now, the other thing I spoke about was an asset protection trust. It is technically a spendthrift trust. It was more geared towards protecting property and assets against Medicaid liens. But I'm talking more now about if you have a blended family, maybe you want to make sure that you're protecting certain assets from beneficiaries who might have a risk of maybe spending the money in ways they shouldn't. So you can have a spendthrift trust, which is a tool to protect the beneficiaries from themselves, or from bad situations like a divorce, if they have huge debts, creditors. So here's how you would set up a spendthrift trust. There's limited access by the beneficiary. It provides protection from creditors. It ensures that they'll have some long-term responsible financial care. It does allow for funds to be given to them for purposes that are consistent with your goals when you set up the spendthrift trust. And it really reduces the risk of people who might have a risk of either being financially irresponsible, or people who maybe have substance abuse issues. Or a lot of times the questions I get are from people who are just really concerned potential divorces for their children, that maybe they think they're in a really challenging marriage circumstance and they're really afraid of what that might look like in the future. If you put assets that they would otherwise inherit into a spendthrift trust, you can protect to a large degree against the other spouse taking assets that were really intended to go to your child, not the child's spouse. So there are some limitations of a spendthrift trust. Some of those are certain kinds of creditors, like alimony. If there's an award of alimony and there is a beneficiary element to the spendthrift trust, some courts in some jurisdictions will, still award alimony even though the funds are coming through a spendthrift trust. There's also some limitations with regard to child support. Some courts and some jurisdictions have something called a necessities exception. That's where they'll let some creditors get to assets that are in a spendthrift trust if the debt was incurred to provide for certain necessary needs like food and shelter and that kind of stuff. Generally, when you're looking at a spendthrift trust, you can't set that up yourself because then you would be basically just avoiding paying your creditors. And so many states will not let you do that. When you set up a spendthrift trust, you do need to designate a trustee, that's someone after you're not there anymore that you trust, and you can have alternates that will, be responsible for managing the funds that are in the spendthrift trust and distributing those to the beneficiary. But it can be a little bit costly to set up a spendthrift trust, but I do think that is also one of the ones where the benefits outweigh the cost, especially if a person needs one and they don't have it in place. It can often lead to some devastating consequences, and I get those calls as well. And you can avoid that by just adding a spendthrift trust to a will or any other estate planning trust that you have in place. So some other things that you can look at when you're thinking about estate planning for a hybrid family, or if you're getting married later in life, is to just be creative on designating beneficiaries on different types of things. So I get a lot of calls for circumstances when maybe someone has passed, and the number one reason that people who have a trust in place need probate is bank accounts. They just didn't think about the bank account and the fact that if you have a bank account and it's just in your name and you pass away, then the bank will not release the funds that are in that bank account, typically without a court order. The way to avoid that would be you could either have somebody else on the account with you, which has its limitations, or you can do something called a payment on death designation, which is a way that the bank will automatically take whatever balance is in that account and they will pay it to the payment on death beneficiary. You can make that beneficiary be your trust, which is a way to make sure that the bank account is not a reason that your family needs to go to probate. Other things to think about for beneficiary designations are other types of assets like retirement accounts and life insurance. Make sure that you have named beneficiaries for those things as well. And that way, those don't end up becoming part of your estate, which then requires probate for them to be distributed. So it's just making sure you're keeping up with those. There's some other documents you should probably think about. This is whether or not you're thinking about getting married again. You should think about a durable power of attorney, a healthcare power of attorney. These are documents that if you don't have them in place, I mean, we deal with these. I know some of the people on this call are estate planning professionals that I mean, just this last week, we had a situation where a family wanted to do an estate plan, but the wife or spouse was incapacitated, could not sign any documents whatsoever. And there was a power of attorney in place, but they had gone online and done something, and the enforceability of the power of attorney document they had in place was very questionable. They needed to have a healthcare directive form as well, but we could not execute that because she could not sign that. And if you don't have these things in advance, the only way to be able to get the authority to act on behalf of another person, like a disabled or a spouse that's incapacitated, is you have to go through an expensive process called conservatorship, where you have to typically get a lawyer, go through a legal process to get the authority that you could easily get with a durable power of attorney and healthcare directive if it had been done in advance. So these are things that contact your plan giving services trust team. They can help you. These typically are documents that are done with along with your other estate planning needs. So if you're looking at this, sometimes it helps to look at the big picture when you think about estate planning, to think about things like what kind of family members do I have? What will they do with regard to having to make tough choices of estate planning as far as what to do with assets if they become joint owners on things? Is that always a good idea? As part of the process, as you can see here, if you don't see the whole picture, you don't see this person's about to go off of this waterfall over here. Um, so yeah, planning for your death won't make it come any faster, but failing to plan for it will make for far more stressful experience on the people that you love. And that's why I encourage everybody to, you don't have to have a complex plan, but you should really think about your plan, put something in place to avoid some unintended consequences. So I've been talking a lot. I don't see the chat thing where the questions might be. Maybe I can turn it back over to Nicole for any questions that might be out there. But I will say, remember, only you can prevent remarriage disasters. Start your estate planning now. So that's it for my presentation. I would love to take any questions.
Thank you. Thank you, Andrew. We really appreciate it. Yeah, if you wouldn't mind making me host again and I can
Yeah, yeah.
look at those things. So, folks, this is your opportunity. This is the time. If you would like to put in some questions into the chat or just go ahead and unmute yourself. I will say I appreciated very much the presentation personally. I appreciated how Andrew, you talked about, some of those pitfalls, but also some real good solutions and things that we can do to prevent these, you know, remarriage disasters later down the road, especially for those that we love. Because I'm sure that if I turned it over to some of my other colleagues, we can definitely tell some stories of sad situations because people didn't, heed some of this advice or do some of these things. And I think it prevents a lot of heartache later down the road. So, folks, this is your opportunity. Are there any questions? Would you like to unmute yourself? Andrew, I think you did such a fabulous job. People have
No
no
questions.
questions.
That's great.
Um, I'll give a few more minutes, but in the meantime, I'll come. Sorry, did someone unmute themselves? Would they like to ask something?
Well, I was just curious, Andrew, with regards to the irrevocable trusts. I know that I have had individuals who have created irrevocable trusts in which they have put property into the trust, sold property out of the trust, particularly high wealth individuals. And I'm just curious, what are your thoughts with regards to using that as sort of a protection of assets plan?
Yeah, so I will say when you get into the high wealth scenario, I do have some clients in that category. There are some additional tools that can be used in conjunction with the trust. And a lot of this has to do with offshore accounting. This is to protect a lot of extreme high wealth. I'm saying into the multi-millions typically. A lot of times, if you don't have that level of wealth, it doesn't really make a lot of sense to set up an offshore protection plan with the trust like that because it costs a lot of money to manage that kind of stuff, to especially get it professionally set up in jurisdictions that do not recognize U.S. judgments. And a lot of times the high wealth are really worried about a huge judgment of punitive damages or something like that that could literally strip a lot of that wealth away. And so part of the strategy for that is to do a combination of several things when you're looking at that kind of level of wealth. It's to establish a trust, but typically these are not U.S. trusts. These are trusts in countries that do not recognize U.S. judgments, so they're basically judgment proof. And then also at the same time, the trust being put into a country that has the laws that would protect the kinds of assets. Um, but for most people, a U.S. asset protection trust will typically provide a lot of protection even against judgments because the assets are not ones they control as long as it was set up properly. There are some states that do allow you to do your own asset protection trust. Alabama is one of those. It has some limitations on it, but you can set up your own asset protection trust with some limits in some states. And you can even do something called forum shopping, which is you can actually set up, for example, an Alabama trust that has laws that are very favorable. And you could put assets in that trust from other states and be able to utilize the protections in that state. So I hope that answered your question.
Yes, thank you.
Mhm.
Great question. And it brings to light to me, I'll just piggyback, Andrew, on what you were saying about this. This is not meant to substitute legal advice because each family, each situation is so different and unique. And that's one of the things I'm grateful for, that in the work we do, we're always consulting back with our attorneys and sending things back to make sure that what we're doing fulfills the needs of that particular situation and that family.
Yep.
Okay, we do have a question here in the chat. What are the consequences if you transfer assets into an irrevocable trust within less than 5 years when you are looking to qualify for Medicaid?
That is a really good question. I have done presentations specifically, I mean, a whole hour just geared on Medicaid and potential ways to maybe avoid some adverse consequences there. So what I will say is they will call that an ineligible transfer in most cases if it was sold or transferred within the 5 year period. What that will mean is you won't qualify for benefits, or they will assess penalties and make you wait a period of time before you become eligible for benefits. So it doesn't necessarily mean you could never get benefits. It means you got to wait until the 5 year period has expired. But there are some other potential strategies, and this is where a case by case analysis would really be needed. There are some other potential strategies that could be implemented if you don't have the 5 years, but you're concerned about an asset like a home being lost to Medicaid liens. If you have a child or a sibling that has lived with the person who needs to go on long-term care a minimum of 2 years, and that's a hard test. So you have to actually prove that you lived with the person who had the need to have long-term care, then there is a 2 year limitation as long as that property is going to the person who provided the care. The idea is that if somebody is, living with you for 2 years before you need Medicaid, then they probably prevented you from being on Medicaid. So they will allow you to have a kind of a 3 year extra ability to only have the 2 year requirement instead of 5 years. But it does have some limitations. Another potential solution, if you're in the spot where you didn't do the 5 years advanced planning, but you really need to go on Medicaid, and I had another presentation I watched. There are some strategies where some people, if it's appropriate for their family, can consider relocating to one of these states like Florida that has an unlimited homestead exemption. Because if you take an asset from a different state where the home was subject to Medicaid liens and you go and buy a Florida home with this unlimited homestead exemption, as long as you don't go through the probate process in Florida, that often is a successful strategy to minimize the risk of there being any Medicaid liens that can attach to that Florida property. So, as crazy as it sounds, you might want to see how sunny and wonderful the state of Florida is, and find a way, if you can reasonably relocate there, that could be a potential solution to help your family in that situation.
Very good. Very good. Thank you. So there is another question also regarding Veterans Trust, if you could expound a little bit on that, or an irrevocable trust if the person who has to qualify for Medicaid has a disabled adult child.
Okay, so there are some exceptions, and I don't do a lot of the military law and some of the veterans laws, but I will say typically if you are a veteran or even the spouse of a veteran, there are often a lot of additional programs that are not available to the typical person to be able to get long-term care that does not have the same limitations that Medicaid has. They're considered, under Veterans Affairs and Benefits. And I'll just say I'm not an expert in that area, but that is something I would maybe look at getting an attorney who does specialize in that area to see what kind of benefits you might could be able to piggyback with either revocable or non-revocable trust to realize that you might be eligible and apply for benefits. And there's a lot of benefits that veterans can apply for that a lot of people they don't even know, or their spouse. What happens is the veteran ends up passing and the spouse doesn't know they could have utilized a lot of benefits and even monthly payments in some cases, disability payments can go to a surviving spouse. So that's something where you really want to get an expert that specializes in Veterans Affairs and make sure you're maximizing the opportunities there.
Okay. Very good. Well, I think we've reached about the end of our time here. I'm going to go ahead and share the last bit of the presentation once more. Let's see. Andrew, if you would give me the
Yep.
co-host rights there. Yeah. If I can get it to go into presentation mode. Okay, I'm gonna switch once more. Sorry, folks. Again. Maybe third time is the charm.
I do see it. I do see the presentation, Nicole.
Yeah, it's not wanting to go into my presentation mode. So for whatever reason, PowerPoint is not cooperating with me today. So it goes. I'll just have to show it from here today. So we do have a few more webinars coming up. If you want to be able to mark your calendars and know what's coming up, we have a few different topics on Medicare, asset protection, and then year-end tax strategies, as I was sharing with you before. If you are interested and you want to follow up and begin that process of estate planning, this is the contact information for the folks at Florida Conference, and you can use that to reach out to them. And then here I also have the other conferences along with their contact information. And so I want to thank you all so much for joining us tonight. I pray that this was helpful to you. Thank you, Andrew, for being so willing to be with us and to give us all this information and for your time. And do I have someone else who may be willing to close us in prayer this evening?
I'd be happy to, Nicole.
Thank you.
Dear Heavenly Father, we just want to thank you so much for Andrew, for the information that he shared to help us, each one of us and our members, to be able to make better decisions as we're thinking of honoring you, first of all, with our estate plan and taking care of our families and making sure that the mission that we care about is also part of what we contribute to in our stewardship of what you give us. And Lord, we just thank you for the opportunity to come together today. We thank you for your love for us. And we just ask that you would continue to give us generous hearts and make us grateful. In Jesus' name, amen.
Amen. Thank you, Jennifer. And we have recorded this, and so we will be passing this on to those who were interested. I know on our end, we will send it just to anyone who had requested the link already. So you should have that shortly or in the next few days in your inbox. And thank you, folks, again. And until next time, God be with you.
Thanks, Nicole.
Thank you, Nicole. Thank you.